This is From Courtroom to Carline, the podcast where we discuss life as a lawyer and a parent.
I'm Rick.
And I'm Jenna.
Your host and partners both in the courtroom and in parenting.
Join us as we navigate the fascinating worlds of life as a parent and a lawyer.
From courtroom dramas to Carline chaos, we'll share insights, anecdotes, and plenty of laughs along the way.
Whether you're a seasoned attorney, a working parent, or simply curious about the intricacies of our dual roles,
this podcast is for you. We'll explore the challenges, the joys, and everything in between balancing a legal career and the adventures of parenthood.
So buckle up as we embark on this journey together.
Now, this is not legal advice, but in every episode, From Courtroom to Carline is a delightful blend of legal insight and parenting hilarity.
Get ready for a roller coaster ride where law meets love and where the gavel meets the car line.
So welcome everyone to this episode From Courtroom to Carline, a legal parenting podcast. Today we have John Nolgren. He's a criminal defense attorney here in St. Petersburg, Florida. He has his own criminal defense law firm. He's been practicing criminal defense here in Pinellas County for the past almost 15 years. He's an experienced trial lawyer and one of the most creative criminal defense attorneys that I know. So John, welcome to the show.
Thank you for having me. And,
welcome.
Thank you. I'm excited to be here.
So let's get right into it, John. Tell us about why you started the Nolgren Law Firm.
Well, somewhat recently, it's only been 6 months, so it's still in the opening stages. I decided to leave my job as a public defender for a whole bunch of reasons and to go out on my own. I'm sure we'll discuss it a little bit later, but I don't have any children, so that's kind of ironic for this podcast. But I think having that freedom allowed me to go out and in this moment start up an ambitious law practice.
Right. So when I started the Fletcher Law practice, I just had one, but expecting two. And I think it does give you a little bit more freedom to, do what you want. But at the same time, when you start your own law firm, it is nerve-wracking because you're banking on your own success and you don't know how it's going to turn out. So it is still a risk nonetheless, but you're willing to take the leap, and it looks like things are going pretty well.
That's right. So far, so good. I have that freedom to work for myself and to be independent, although ironically, I feel like I've never worked harder.
So what sort of hours are you having to put in?
I guess maybe the better question is, what hours am I not putting in? I was thinking about that type of question for this podcast. And one of the things I'm struggling with right now, and I think it's okay for the beginning stages of a law firm, but is finding time for yourself. Because when you're doing everything to sustain your practice, it also means that you have to work extra hours after hours. So I'm trying to take intentional pauses for myself, but when I'm not, I'm frequently working to keep up with business.
So are you currently a solo practitioner?
Yes, I'm a solo practitioner. I'm just doing it myself. I'm doing everything for now. Hopefully, though, in the not too distant future, I'll be able to take on some assistance to help me.
So I can certainly relate to that. Before 2023, I myself was a solo practitioner, and you basically have to do everything, the clerical work, the marketing. It all falls on you, so it's a lot to take on. Tell us, how have you adapted from working at the public defender's office to working and starting the Nolgren Law Firm?
So as a public defender, you do stay very busy, and in fact, in my position when I left the public defender's office, I was handling primarily homicide cases, which involved a lot of litigation, a lot of depositions. And so a lot of my time, even after work, was dedicated to preparing for the daily rigors of that job. The difference, though, is that as a public defender, you're getting basically a stipend every month. Your salary is not changing no matter how hard or how little you work. You don't particularly benefit from success in the courtroom, at least not financially. And so taking on my new practice, I've worked even more hours than before when I was a public defender, but it feels much different. It feels much more like an investment in myself as well as my practice. And so that transition, I think, has been highly motivating to have that feeling that you're working for yourself.
You had said it's a different kind of stress, and I
Yes.
can definitely relate to that. I've talked to other, private attorneys, how I said I was so stressed at the public defender's office with so many cases.
Yes.
But even having, Rick having the firm and me joining, it still is stressful, just a different type of stress. I don't know how to explain it, but it's still stressful. It's not as less stressful as I thought, but it's still good.
That's exactly right, and I think that part of the reason why it's a different stress is that you're doing different things to maintain your law practice, not just what's happening in the courtroom. And there's also a learning process to that. There's a learning curve, so it's exciting to be learning new things, but it's much of the work is very different than you would perform as a public defender. So, for example, this morning I was working to set some out-of-state depositions, which have a lot of logistics. And ordinarily, my last job, I would send instructions to my assistant who would do all of those things for me. And now I'm spending all of that time working out those depositions on my own, none of which, by the way, has anything to do with how the depositions are actually going to go as far as the questions being asked and whatnot, but all of logistics of planning where to have them, who to hire, paying court reporters, all that kind of stuff. Ordinarily, those were things that had been done for me. But it's exciting to learn new things. I'm always up for a challenge.
We're definitely in the same boat. We just hired our first legal assistant through Get Staffed Up. So she's over in Argentina, but she hasn't been a legal assistant before. So we're having to teach her essentially what our legal assistants did for us at the public defender's office. So it's definitely a work in progress. She's great, but we're dealing with those same struggles.
Yep.
And I have to give Jenna a lot of credit because I have never had an assistant when it was just me as a solo practitioner. And so I see the time and effort that it takes to train someone, especially a legal assistant. And Jenna's really taken on the role for that. So I appreciate that because I didn't know how to do it. And I'm just grateful that you're able to come through on that.
I appreciate it.
So going back to the public defender's office, obviously we worked together. We tried many cases together. How long were you there for?
Almost 13 years. I left right before my 13th year anniversary.
Okay. Now, you talked a little bit about, when you're working for yourself, it's very motivating. How did you stay motivated at the public defender's office, given the number of cases and how long you'd been there?
One thing I really appreciate about being a public defender, and as you guys know, sometimes or almost all the time, there's a stigma associated with public defenders, that they're not good attorneys, they're overworked, they don't care, they're working for the state, all that kind of stuff. But the reason that I did it, and I suspect you all as well, and I know you guys did it for these reasons, is that it's a very pure form of law practice. You don't have money that's a barrier for your clients. So in other words, you are doing what you want to do on the case, and it's not dependent on whether your client can afford what it is that you want to do. So that is one aspect of the practice that I miss. In that, in the private practice, right? It's you have to get paid. That's how you make your living. That's how you're able to sustain the law practice, and that's a whole other aspect now that I'm learning, which I really still wish I could just have that pure form of practice with just me and my client doing exactly what we want to do in court, and it doesn't have anything to do with money.
What would you say your biggest struggle has been thus far in starting your own firm?
That's a great question. I think it's everything that doesn't have to do with what's going on in the courtroom. So in other words, keeping your books, all the financial aspects of it, dealing with marketing, all of these things, which quite frankly, I prefer not to be doing. However, you got to bring in business. You have to bring in new clients. So it's necessary. And that goes back to what I referred to earlier as part of the learning curve. I'd rather not be doing it, but at the same time, I am learning, just like you guys did, how to market yourself, how to build a name for your firm. And hopefully in the not too distant future, I can hire somebody that'll do all that stuff for me, and I can then train them or teach them how to do it after learning it myself.
One thing Rick and I talk about is, in law school, they should probably teach you the marketing aspect of it, because we're three great attorneys, and it would be nice to just be able to go off on our own and practice law, but we have to also learn the marketing aspect and get clients to know who we are and get our name out there. So that's definitely been something that Rick and I have been trying to work on, so that clients know, who we are. And, you're a great trial attorney, and it's just, you've got to learn to get your name out there. So we're glad you're on our podcast.
Right. It's ironic too that, and non-lawyers maybe wouldn't know this, but you would think in law school they would teach you how to be a lawyer. They would teach you how to deal with a client, how to maneuver in a courtroom, how to market a law firm, how to pass a bar exam. The irony, though, is that law school really teaches you none of those things. And when you leave, that's still a whole new learning process. Then you go out into the world to figure out how to be a lawyer.
And so one of the things that always stuck with me is that I was told the most successful lawyer is not the best lawyer. And so that took me a while to learn that. I didn't learn that until I started my practice. And it's not something that you really know until you jump in. And so that's what we're kind of coming to grips with. And, you may be the best trial attorney out of anybody, but if people don't know who you are, then it doesn't matter, and you're not able to make that difference in your clients' lives. So we've definitely learned that lesson. Now, obviously, you like to do things outside of the courtroom for fun. Mm-hmm. So tell us, what are some of the things that you try to do just to keep your mind and body healthy?
Right. And so when I take those intentional pauses for myself, the things that I usually gravitate to will be anything sports, golf, softball, riding bikes, exercise. Love movies, and I love to travel, and I love eating. So I tend to eat fairly wide variety of food, and very adventuresome, and that brings a lot of pleasure to me as well.
Since starting your practice, have you found yourself not being able to do a lot of those things like you used to be able to do when you were getting paid a salary at the public defender's office? For sure.
Where I'm at right now, it's early on in the practice, so I feel that putting in those extra hours are necessary right now. I feel like I'm building, hopefully, a successful law practice, so I don't mind sacrificing those hours. But in the long run, you've got to find a way to set out that time for yourself. So it's definitely difficult, but at the same time, if you're intentional about doing it, setting aside just those little hobbies, those little things that'll give you that little emotional boost that you need to get through the rest of your hours. So having your own practice, you're free to do what you want in a way, but at the same time, if you're motivated to keep your foot on the gas, then that means you're working a lot.
I remember when I first started my practice and you were still at the public defender's office, we would play golf all the time, lots of outings. And then it's gotten to the point where I can't remember the last time we played golf together or the last time I played golf at all. It's almost like a pipe dream at this point. Mm-hmm. And, that's not necessarily a good thing to say, because you need those escapes. You need that time to yourself just to both mentally rest and then physically, just stay fit and stay healthy. So, finding that time for yourself is very important, and it's going to become even more so important when you get the work and you get the cases and you get the money and, your practice is growing. You always have to kind of go back to that and remember that that's a high priority, and you got to maintain that.
Right. And I think probably the way we've been playing in recent years, it's best that we didn't remember that past experience.
Can we edit that part
out? No, and that just goes to your larger point of trying to find time to take for yourself and do the things you like. And we should be playing golf more often, but we're both in a position right now where it's just hard to find the time that we overlap with.
What is it about a criminal trial that you like the most?
What I like about criminal law as compared to civil law, which civil law is essentially money is at stake in those types of cases. In criminal law, however, the stakes are someone's freedom, someone's liberty. And to me, that's highly motivating. To me, that makes it such that when you're out there in the courtroom, you're really fighting for something that's truly important. Also with criminal law, it's wild. Crazy things happen, and those types of cases are really fun to deal with. It always keeps you excited and interested in your cases. And so those are the two biggest reasons I think I prefer criminal practice above anything else.
What is your most memorable case or trial?
So I have quite a few memorable cases and trials, and I thought about maybe one that I would talk about today. I'm not so sure it's my most memorable, but I think it might be the funniest one. So this had to be probably 10 years ago now, but I had a shoplifting case, a misdemeanor, wherein part of the undisputed facts were that the client admittedly stuffed about $150 worth of meats and cheeses down his pants before trying to check out at a local Publix. That was our baseline, right? That's what we started out with. So our defense theory was that he actually took out those items from his pants, tried to pay for them, didn't pay for all of the items for whatever reason, but we were trying to blame it on basically a cashier's mistake, and he didn't realize the cashier had not checked out everything. So that was a decent theory. We were setting it up all during trial. And at the halfway point, when it was our turn to present evidence, our client was actually insistent upon testifying, which we were trying to tell him, we think we're in a good place, relatively speaking, and we're not sure what you can add to the case. But he wanted to testify anyway. And so we'd been setting up this theory that the cashier had made a mistake in checking him out. Our client blew that out of the water. We had to shift. We had to pivot during trial because our client's later theory as to why he put all of those meats and cheeses in his pants was not because he was trying to steal or anything like that. It was because he believed that the loss prevention officer in the store was cruising him, which is a term used for basically hitting on him, essentially. And so our client's plan was to then stuff the items down his pants to see how this person reacted, to see whether it was a loss prevention officer or not. So that then became our theory. The jury came back not guilty.
Wow.
That's right. So that's what makes the story funny because, you typically in a criminal case, if you're shifting your theory halfway through, it's not a good scenario for you. Usually not high chances for success. My best guess on that is that the jury just found the case to be so amusing and absurd that, it was worth, giving this guy a break. In the end, Publix got all of their items back. I'm quite sure they didn't put them back on the shelves, but, it was sort of a no harm, no foul situation.
I think a case like that, again, just goes to your testament of how, great of a trial attorney you are because, not many people can shift in the middle of trial and shift that defense. So it doesn't surprise me that it was a not guilty, and probably a lot had to do with you, not necessarily the client.
Well, one thing non-lawyers may not know is that one decision that clients have 100% the right to make in a trial is whether to testify or not testify. So a lawyer can tell his or her client till they're blue in the face, you shouldn't testify. We've got this thing set up. We're looking good. If that client says no, then you have no choice as a lawyer. And the secondary aspect of that is once your client has put out a theory out there, well, you're not going to argue against your client. So one of the phrases I like to adopt during trial is to go deeper into the crevasse. In other words, if there's a hole, if there's some kind of dirty aspect about your case, embrace it, go deeper into it. Sell out for your client, which is what we did during that trial, and it apparently worked.
I love that. So, John, we thank you so much, but now we're going to go into our segment. We're going to keep you here for it,
right.
Of what happened to Florida Man. So we'll go into that.
So in this episode, or in this segment, we've got a story about a man in Florida who was in a porta potty. The police were called out because I guess there was a report of screams or yelling coming from within this porta potty. So when a police officer arrives, she hears some screaming and yelling inside the porta potty. They don't really go into detail about what the screaming specifically was about or what he was saying, but she ends up opening the door and seeing the man in there, and then there's drugs and paraphernalia in plain view. Now, you would think if you didn't know the rest of the story that would have been an open and shut case, the police seeing this man in the porta potty with the drugs, but the case was not filed on, or there was a no information, meaning the prosecutor elected not to file charges. He didn't even have to go to court. And so, my first thought as a criminal defense attorney would be, well, maybe that's because the police officer didn't have a right to open that porta potty door in the first place. So, people, non-lawyers, you have a reasonable expectation of privacy. And if the police, search an area where they don't have a right to search, then you can later throw out that evidence if there's anything uncovered from that search. So when I read that story and I read that they didn't file charges, my first thought was they didn't have a right to open that porta potty door and see what was inside. And, if you're using the bathroom inside a porta potty, I think that's a pretty good reasonable expectation of privacy.
John, do you think the state got it right by not filing charges in that case?
Well, of course, but I think that about every case the state drops. I do have an alternate theory that's really not inconsistent with Rick's, but maybe another factor. I read an article about this story that indicated it seemed like the man got his foot stuck in the door and was screaming for help. There is a Florida statute that says a person is immune from prosecution in a drug case if they are seeking assistance for a bona fide medical issue or overdose. So I thought perhaps the prosecution looked at the case, realized it was somewhat absurd, but might be construed as a person screaming for help. How he got his foot stuck in a porta potty door,
with drugs in
I don't
plain
know,
view.
right? And the thing is me personally, I try to avoid porta potties at all costs.
Yes.
And so I don't know what leads a person to strike the mood in there, but to me it seems like maybe the worst place to do just about anything. Another follow-up on Rick's point, the expectation of privacy. Your listeners may know, right, in the United States, a lot of times stalls have cracks in them such that you can see through a gap underneath or above, which is, in a lot of other countries, kind of mortifying. So maybe that factors into the expectation of privacy as to how much could be seen inside the porta potty. Is there really true privacy in a lot of these places?
So, like I said at the beginning of the show, one of the most creative trial attorneys that I know, there's just a real life example of the creativity at work. I never would have thought of the bona fide medical reason being as a reason why they didn't file charges. So again, very impressive, John.
Again, I don't know how you get your foot stuck in a porta potty door such that you can't get it out yourself, but the man may have been in some kind of peril. Certainly if you're doing drugs in that situation, most likely he's got a lot of issues going on in his life. So I'm glad that the case worked out for him.
So John, if people are arrested or charged with a criminal offense, where can they find you?
You can Google me, John Nolgren. You can also visit my website at www.nolgrenlaw.com. I have an uncommon last name, and there's a silent H, so I'm going to spell it out for your listeners. My last name is spelled Nohlgren.
We definitely appreciate you being on the show, and we know you are going to do wonderful in your practice as an attorney, and we cannot wait to see where your firm goes.
Thank you, and thank you for having me, friends.
Absolutely. So this has been another episode from Courtroom to Carline,
a legal parenting podcast.